Hi, I'm Arlen Ettinger. I'm president of Guernsey's, and we're here at the Tavern on the Green restaurant, the spectacular restaurant that sadly will be sold at a bankruptcy auction on January 13th, 14th, and 15th. Many know of Tavern on the Green as certainly one of the world's most famous restaurants, and more than just a restaurant, it's a place to be for the...
It's an historic moment for New York. One of the most storied restaurants in the city is being sold off piece by piece. All told, the items such as the Tiffany lampshades, crystal chandeliers, the Christmas trees, the flatware and linens have an appraised value of $8 million. But the most valuable item is not for sale: the name.
It's been appraised for $19 million. It's the single most valuable asset of the bankruptcy estate, and the single most valuable asset that creditors can look toward in order to recover.
The name is at the center of a contentious trademark dispute between the City of New York, which owns the Tavern on the Green building, and the Leroy family, which has operated the restaurant under a city license since 1976. The Leroys lost the license this summer, which forced their operating company into bankruptcy. The family, however, trademarked the name in 1981 and now wants to take it with them.
Mr. Leroy trademarked this name, and it's an incontestable trademark. It's not about a personal feeling or he said, she said. It's about the law. In the trademark law, it's an incontestable mark. They had a window to contest it. They didn't contest it. I'm not a lawyer, but it seems pretty cut and dry to me.
But things are rarely cut and dry in trademark law. The city's lawyer, Gerald Singleton, argues that the name Tavern on the Green is inextricably linked to the building in Central Park, and the Leroys, as licensees, were merely custodians of the brand.
People see that name, they get in an airport, take me to Tavern on the Green, they expect to wind up in Central Park at West 67th Street. And we don't want another restaurant at another location. You wouldn't want to find yourself in Astoria or Brooklyn.
According to Singleton, the city wasn't even aware of the trademark until 2006, when the Leroys went to register a mark for a line of Tavern on the Green salad dressings. So you sent the letter in 2006, and yet you haven't really pushed any further since then. Is that right?
Okay, that's the argument they're making. They're saying, you, the city, slept on your rights. You didn't enforce your rights. And so the city's answer to that is, well, we didn't really have to do anything. Once you send a letter, that's enough. A simple warning letter is enough to preserve your rights.
It's a compelling argument, says Teresa Gillis, an intellectual property attorney with the law firm Howry. But she says the delay could work against the city in court.
In the trademark world, delay always works against you because you're expected to act promptly. And here the city's sending a letter and then doing nothing arguably lulled the Leroy family into believing, okay, the city really isn't asserting its rights.
It is widely understood that the restaurant will be operated by Dean Pohl, the operator of the Loeb Boathouse restaurant in Central Park. Complicating matters, however, is the fact that Pohl has yet to actually sign the licensing agreement. Creditors Counsel Norman Cannell.
It's our belief that Mr. Pohl is not signing an agreement with the city unless the city can deliver the name to him.
From the standpoint of Dean and going forward, we have made quite clear that we would call the place Tavern in the Park, and the city has accepted that name. If that were the court's ruling, it would become Tavern in the Park, and it would be a continuation of everything that's been there before in terms of the iconic status of this very special place in New Yorkers' mindset, and as well as the rest of the nation and the world.
Is there any reason to think Dean Pohl won't sign the actual license?
Oh, don't bet against that. No, he will be operating that restaurant starting March 1.
LePatner confirms that Pohl has secured $25 million to complete the renovations promised in his bid. This means the city will likely avoid the doomsday scenario of not having an operator for the restaurant after the Leroys leave. That's little comfort, though, to the 450-plus creditors, ranging from the New York Hotel Trades Council and Association to hundreds of small business owners still waiting to collect their debts.
The city has opposed virtually everything that the debtors and the creditors have tried to do to maximize the recoveries and the returns to creditors from the outset of the bankruptcy.
Well, you know, it's not the city's fault that there's a shortfall and that the creditors are exposed, and the city shouldn't be, you know, making up the difference here. I mean, the people of the city of New York should not have to pay for something they already own.
there's a lot of scuttlebutt out there about what will take place in this beautiful building in the years to come. It certainly seems like it's going to reopen in some new configuration, and hopefully that will be wonderful in a different way. Certainly, I think I'm safe in saying that there is no place just like this.
A decision in the trademark dispute is expected in late January. For The Deal, I'm Suzanne Stevens.